With a 99.4% success rate, Raju Law is one of the largest immigration law firms in the USA. Besides our founder and principal attorney, we have 6 associate attorneys along with 100 law clerks, case managers, and officials. The law firm is headquartered in Washington, D.C. Other than that, there are a branch office in Georgia and a country office in Dhaka, Bangladesh. What is a writ of mandamus? In simpler terms, in the immigration process in the USA, a writ of mandamus is a remedy for visa applicants using which they can effectively address and resolve the unreasonable delay in their visa processing. Why should you file a writ of mandamus? If anyone's visa application is stuck in an administrative process, he or she may file a writ of mandamus requesting the court to ask the concerned embassy or consulate to adjudicate the visa application within a reasonable time. Who can file a writ of mandamus? Anyone can usually proceed with a writ of mandamus if the administrative processing has been ongoing for more than 2 months for a student visa and 6 months or more for a visa of other categories. Processing time. After filing a writ of mandamus, it usually takes around 6 to 8 weeks to get a response from the concerned agency like USCIS, embassies, consulates, or others. For a writ of mandamus and any lawful immigration-related services, contact the address and phone number shown on the screen. You can also mail at info@rajulaw.com. Raju Law is your trustful address for any assistance and advice regarding immigration to America.
Hello everyone, and welcome back to the weekly live session hosted by attorney 𝗏𝘂𝗍𝗏 and Associates. For today's session, I am your host, Isabella Rosario, and with me I have none other than the principal attorney of the firm, Mr. 𝗏𝘂𝗏𝗏. Today, our topic of discussion is a very important topic that impacts a lot of applicants to the USCIS program. We are going to be talking about how to expedite family-based green card system. Mr. Mahajan, please enlighten us on this topic.
Thank you very much, Isabella. Thank you everybody who are watching at this moment and who will watch our recorded show in YouTube and Facebook and LinkedIn and other social media. I welcome all of you to our show. This is indeed a very important topic, how to expedite family-based applications. You know, in some categories, like when a US citizen apply for their siblings, it takes almost 13 to 15 years. In some countries like India, China, Mexico, and Philippines, it takes even longer than that. So a lot of time people ask the question, how to expedite family-based applications. Number one, I have to say that if there is any delay related to visa bulletin, there is no way to expedite it. Please, you have to remember this thing. If the delay is related to the visa bulletin, and most cases, this longer time comes with a visa bulletin related delay, there is no way to expedite it. However, there are some other kind of delays you can definitely expedite it, and that is our focus of discussion today. Number one, if you can file all the applications properly with all the appropriate fee and all the appropriate documents, definitely it will save your time. A lot of time I see that people submit I-130 application for their family members, and after like 1 year or 2 years, the I-130 application gets rejected. Then you are losing 1 or 2 years of very valuable year. So please file I-130 application properly with appropriate fee and supporting documents. Next thing is, once your priority date is present in the visa bulletin, then you can apply for the next step, which is if you are in America, I mean, if your beneficiaries are in America, they will submit I-485 application. However, if they live in a foreign country, they will apply for immigration visa petition, DS-260 form to your local US embassy. Now, once you submit your form, if you are not getting the interview date, in many cases, I know that people don't get interview date even like after 2 years or 3 years of submitting your DS-260. Once you are documentarily qualified, embassy has a responsibility to schedule an interview and take the interview. If they delay more than 6 months, you can file writ of mandamus. However, before filing writ of mandamus, there are some other remedies that I want you to try. Not all the time it works, but it's worth trying because it's very free. It's free or very inexpensive. Number one, you can contact your local congressman, US congressman, your federal congressman or senator. Please do not contact your state senator or congressman for this immigration purposes. They don't have jurisdiction over USCIS. Only federal congressmen and excuse me, only federal congressmen and senators have jurisdiction over USCIS. Contact your federal congressman and senator and request for expedite process. Sometimes it works, sometimes it doesn't, but it's worth trying. Then, if it doesn't work, there's another office called Immigration Ombudsman. Contact Immigration Ombudsman office and request for expedite processing. Again, sometimes it works, sometimes it doesn't, but it worth trying. And if you need help about this thing, we can help you about contacting your local congressman, contacting the Immigration Ombudsman office. Of course, you have to pay us some money because we're like a professional law firm. You have to pay us money to do this thing, but definitely we can help you with that. If your case is not expedited, even after contacting your federal congressman, senator, or ombudsman office, the last resort is filing writ of mandamus. A lot of people has misconception about writ of mandamus. They think that if they file writ of mandamus to any federal court, immigration officials, especially people who work in a foreign US embassy, they will be angry, they will be mad, and they will treat you badly, which is not true, because you are taking the service of American judicial system. America is land of law. Law is above everything here in America. So if you take any help from American legal system, no US official, including the embassy official, can be angry or mad and treat you badly. There is no way. If they do that, that's even a bigger crime. So please don't worry about that part. So, but before you file writ of mandamus, there are some waiting period. Like, for a student visa, usually I say that you have to wait 6 months. For H-1B related kind of things, I say you have to wait 2 months. For family-based application, after documentarily qualified, if you do not get interviews within 1 year, or even after interview, if you do not get your result within 1 year, I encourage you to file writ of mandamus. And the process for writ of mandamus is we file a writ in a federal district court. We request the judge to instruct USCIS official or embassy official to expedite your case faster. And that really helps. So far, based on our experience, people get their result within 60 to 90 days of filing writ of mandamus. This is a very good remedy. I understand this is expensive. We charge $3,000, plus there's a court fee, there is a FedEx shipping fee, but at the end of the day, it's very worthy. So, bottom line of our presentation today, if your family-based application is pending in USCIS or in a foreign US embassy, if you are documentarily qualified, if you are not getting interview, or if your interview is done, but you are not getting a result, if you wait for more than 1 year, you are qualified to apply for writ of mandamus. This is really great service. I advise all of you to take this service. That was our presentation on how to expedite your family-based application.
Thank you so much, Mr. Mahajan. That was a very enlightening discussion that you had right now, and I'm sure that we all extracted a lot of valuable information from your speech. In the meantime, we already have a question waiting for us. So Mr. 𝗦𝘂𝘃 asks, hello, sir. Am I eligible for applying for EB-3 while asylum case is pending if I have an employer? Mr. Mahajan, your response, please.
Thank you very much. This is a very common question. I get this question almost every day. And the short answer to question is yes. However, there are some things you must know. So if your immigration case is pending, then you are qualified to apply for EB-3. And pending means it is pending in USCIS, it is pending in immigration court, then you are eligible to apply for EB-3. However, if your case has been rejected by any immigration judge in immigration court, then you are not qualified to apply for EB3. If your case is rejected by USCIS and it is pending in immigration court, then you can apply for EB3. However, if your case has been rejected by an immigration judge, then you are not qualified. Before that, until that, you can qualify for EB3. That's why a lot of time when people come to me when their case is pending, they want to apply for EB3, I advise them to make sure they will not schedule final hearing, individual hearing soon, because there is a chance if your case is scheduled for individual hearing, there is a chance that judge may deny your case. If you are applying for EB3, make sure you do not take any schedule. And how to do that? Your attorney will take care of that part. They have a lot of tools to, early schedule, late schedule kind of things. Let them take care of it. However, just tell them, my EB3 case is pending. Please make sure I will not take any individual hearing date. And the short answer to the question is yes, you're qualified for EB3 application.
Thank you so much. I hope that answers your queries. Audience members, at this point, I'd like to tell you that as an operating law firm, we often have lots of questions flooding our emails, flooding our communication systems regarding all kinds of topics. So regarding the green card status, I would like to read out some questions and ask for Mr. Mahajan's thoughts on them. The first question I have waiting for us is from Mr. Sheikh Mofisur Rahman, and he asks, I got green card of USA and it was expired in 2014 and I was outside of USA for the last 18 years. Now I want to renew my green card. Is there any possibility to regain it?
No. Usually, like when somebody's green card is expired and they try to, renew it within like a short time, I would say within 6 months, there are some ways to take care of that matter, but it's been more than 18 years. So your green card is lost, you have already lost it, you have to reapply it again. The way you got your original green card long time ago, you have to follow the same procedure again. Unfortunately, you cannot renew it.
Thank you so much. Another client has asked us, I live in Bangladesh and have been working as AVP, Assistant Vice President at Citibank Limited Corporate Division, local bank, not international. I want to migrate with my father, mother, and my own sister in the USA. Is it possible? My marital status is single.
The short answer is yes. It is. You are eligible. It is possible to migrate to America. The question is how. There are literally a lot of ways. There's EB1, EB2, EB3, EB4, EB5. There is also H1B, O1, L1. There's a many kind of visas, F1, M1, J1. So the question is, which way you will follow to come to America? That's the question. And the information you gave me, that's not enough. I advise you to take an appointment, and before the appointment date, please send me your detailed CV. I will study your CV and I'll be able to advise you what is the best course of action for you to immigrate to America. You can also join our live session in every Sunday. So probably next Sunday, you can join with us and ask the question directly. But based on the information you provided to me, short answer is yes, you are eligible to migrate to America, but we have to determine which way.
I hope that answers your queries, Mr. Alam. Ms. Tahmina Akhtar has asked us, my husband has visit visa B1 or B2 of USA, but I have no B1, B2 visa. I have 2 children who are under 18. Our whole family has travel history in 3 countries, Oman, others are Asian countries. Currently, I'm doing a job in a local company in Bangladesh. Now I want to settle with my whole family in the USA. What are the possible options for me or my husband?
So since your husband has a B1, B2 visa, he can come to America. He can see what are the opportunities. Again, I need to know more information about you, not about your children or anything. What is the education background of you? What is the financial background of you and your husband? If you qualify for EB5, that's the investment-based visa, you have to invest $900,000 to America, which is a lot of money. But a lot of people in Bangladesh also has that money. If you qualify for NIW, that's one option. If you qualify for EB4. So there are many options. I have to see like which one you qualify, and then you have to apply. Right now, the best answer I can say is like try to take an appointment and discuss with me with more information.
I hope that answers your queries, Ms. Akhtar. Mr. 𝗦𝘂𝘆 has asked us several queries. The first of his query is, what will be the total cost per month of 5 family members in the USA at California?
It's very hard to say. California, there are some homes that cost like a $10 million, $20 million. There are some homes that will probably cost like $200,000-$300,000. That's just the price of the home. Similarly, like it depends on your income. It depends on the lifestyle you want to do. It depends. You can literally survive without any money at all. America, especially California, New York, these states are very immigrant friendly, very low income people friendly. So you can survive with a very few amount of money. At the same time, if you want to have like a lavish life, that is also possible with a lot of money. So it depends.
He also asks, will my children get free education while staying in the USA as a child of an international student before getting green card?
Yes. Education in public school all over the America is 100% free. Not only education is free, they also get free meal in the school. It doesn't matter you are an international student or green card holder or citizen. Education until 12th grade is 100% free.
The last query from Mr. 𝗦𝘂𝘆 is, as I will be allowed to work 20 hours during my study and I won't be able to cover my whole family living expenses by working part-time, so how much expenditure should I have to take out from my own account?
Again, it depends on your income. Like even though you're working 20 hours per week, if you get a very good job, if you make a lot of money, then you may be able to spend all the, you have to cover all of your expenses from your income. If you do not make that much money, then you have to pay from your pockets. It depends on your income and depends on your expenses.
Thank you so much, Mr. Mahajan. Another person has given a bit of background about himself. The background regarding Mr. MD 𝗟𝗡𝘆 is, I went to the USA in 2013 through student visa. My visa validity was from 2013 to 2018. I was doing ESL program under MBA degree in Ohio City, and after 1 month, I changed my university and I extended my I-20 up to 2020. And finally, I came back to Bangladesh in 2020 willingly. My first question is it counted as overstay?
What is the last couple sentences? Can you please read that again?
Of course. My visa validity was from 2013 to 2018. I was doing ESL program under MBA degree in Ohio. And after 1 month, I changed my university and I extended my I-20 up to 2020. And then he came back to Bangladesh in 2020. So is this overstay?
No, I don't think so. I don't think so, because you came back to America within your extended I-20 extended period. So if it was within I-20 period, then it's not overstay. However, if there's other kind of information, you can send me all of your I-20 from beginning to end, and then I can check if there's any gap. If there's any gap, then that can be counted as overstay. Even sometimes like a 1 week, 2 weeks, or 1 month kind of overstay is manageable because there are a lot of grace period and other options. But I don't think you did overstay.
He also asks, my wife and I faced interview on May 2023, and we both were refused. In that case, what should I do, or how can I again go to the USA?
When you say refuse, there are some kind of refusal with administrative process. Can you please tell me if it is in administrative process right now? It is pending in administrative process. If it is pending in administrative process, then you can wait. And also, if it takes long time, you can file writ of mandamus, but there's a chance that you'll get visa. However, if it was rejected, and then you have to apply again. Unless they bar you for like 10 years, 20 years, 90 years, you can always apply anytime if you want.
Thank you so much, Mr. Mahajan, for answering his queries. Another person named Mr. MD 𝗟𝗡𝘆 has asked, currently I have my visit visa of USA. I want to change my status from B1, B2 to F1. My question is that 1, how long it may take? Number 2, what documents I should take from Bangladesh?
So how long it may take, it depends on whether you are trying to change your status from within America. So when you come to America under B1, B2 visa, you have a 6 months period. You have to leave it. However, if you apply for change of status from B1, B2 to F1, you don't have to follow that 6 months restriction. You can stay as long as the process takes. Usually it takes like 6 months to 1 year to change your status from B1, B2 to F1 from within America. However, a lot of time people go to Mexico, Canada, or your home country, Bangladesh, and you can apply for student visa there, take the interview, get it approved, and come back. That may take shorter. However, the problem is there's a chance that your student visa application may get rejected. I mean, that may get rejected even within America too. So there's another question. A lot of people ask me this question. I have a valid B1, B2 visa. I applied for F1 visa and it get rejected. Is my B1, B2 visa still active, valid? The answer is yes. Your B1, B2 visa is valid until it expired. So short answer to your question, it depends. If you apply from within America, it may take 6 months to 1 year. If you apply from outside of America, it takes shorter time, sometimes 1 month to 2 months, but there's a chance that your visa will not be approved, like accepted. What is the second question?
The second question was what documents I should take from Bangladesh.
Okay, good. Second, let me tell you the entire document list. Number one, you have to have a admission. You have to have a I-20 from your university, and you have to show enough financial stability, enough financial statement for 1 year's academic tuition and 1 year's living expense. Let me give you an example. Let's say you got admission to a university called ABC University, and 1 year tuition is like $20,000, and also 1 year living expense is $20,000. So total, you have to show bank balance of $40,000 US. Now, if you say that, well, I got a scholarship for $10,000, then you have to show bank balance for $30,000. If you get tuition waiver for like another $20,000, then you have to show bank balance for only $10,000. So other than that, bank statement, bank balance, bank solvency, you need to bring your copy of your passport, your visa, all the like a personal kind of matters. But other than that, you do not need a lot of things. Oh, by the way, birth certificate. Try to get your latest issued birth certificate. Sometimes that is required too.
Thank you so much, Mr. Mahajan, for answering his question. Another question submitted by Miss Yasmin Akhtar is, my daughter is on F1 visa, and our whole family has the visit visa of USA. Now we want to settle in the USA permanently and stay with my daughter. What is the legal procedure so that we can settle with full family?
Again, it depends on your background. There's a lot of categories. There's a lot of options to settle down here in America. The question is, which one is best for you? Again, I advise you to take appointment, talk one-on-one. And I understand, appointment means like a paid appointment. A lot of time people say, oh, it's very hard to get your appointment, which is true because, a lot of people try to talk to me and I have a big law firm to run. I need to pay a lot of attention. I have my personal life, I have family. So I understand if you go to our website, there's two options, paid appointment, free appointment. Sometimes it takes 4 or 5 months just to get the free appointment. Paid appointment is faster to get, but you have to pay money. I understand. I'm sorry for that, but I cannot help other way. So if you take our appointment, if you tell me your details background, and I'll be able to tell you which option is best for you.
Thank you so much. We have received another question from one of our viewers. Mr. Azim Ahmed asks, what if any student has a visa rejection from Australia? Will it be any problem to get an F1 visa?
No, usually visa rejection from foreign country has no impact on American visa application or any other country visa application. So let's say you apply for F1 visa from America, it got rejected. Doesn't mean that your student visa application from Australia will get rejected too. However, there are some criminal conviction that these countries share, not all. Like if you have like a petty crime, like let's say you are living in UK for like 5 years and you had like a multiple small claims, like you probably did like shoplifting or other kind of things. Those kind of criminal record, most of the countries do not share with other countries. However, if you have a big criminal record of like a murder, rape, or like other kind of terrorism or other kind of big crimes, then they share with other countries. Unless if you're convicted for those kind of big crimes, one country will not share any record with the other country. And especially visa rejection from one country will have no impact on other countries' visa application.
I hope that answers your queries, Mr. Ahmed. We have some more questions from our archives. So a question submitted by Mr. 𝗦𝘂𝘃 𝗟𝗶𝘆 stands as, We are sportsmen, 4 people, all friends, and we are all sportsmen. And we even got national awards, and we are representatives of the national team of Bangladesh. We want to settle in the USA. Is there any possibility to get green card through our national celebrity status?
Yes, the name of the category is called EB1. If you have national or international award in any field, you qualify for that. And application process is pretty straightforward. You can apply from within America or outside of America, from anywhere in the world. There's 2 steps. The first one is called I-140. First, you have to apply for I-140. You have to establish that you're a person of extraordinary ability. There are 10 criteria. You have to meet at least 3 of them. But if you have national or international award, most likely you qualify for at least 4 or 5. So once your I-140 application is approved, then you go for actual green card application. You get the green card and you come to America. If you have national or international award, you definitely qualify for EB1, and this is the best category for you.
I hope that answers their queries. Another question has been submitted, and this client is one of our own clients. This question comes from Mr. 𝗦𝘂𝘆 𝗟𝗶𝘃𝗲, and he asks, I have B1, B2 visa. I am an imam of a mosque of USA. I want to extend my visa validity because it will expire on June 2023. Meanwhile, I have plans to come back to Bangladesh very soon. His I-140 form has already been approved, so what should he do now to extend his B1, B2 visa?
Well, since his I-140 has been approved, he cannot apply for the second step at this moment because there's a huge backlog for priority because of the priority date in visa bulletin. So I advise him to apply for extension of B1, B2. However, when the extension application is pending, you can go to Bangladesh anytime and try to come back again. It will have no impact at all. So, yeah, his best case scenario would be to apply for B1, B2 application extension.
I hope that answers your queries, Mr. Kashumi. And the final question we have in our archive is submitted from Mr. 𝗦𝘂𝘃𝗲, and he says, I faced visa interview for student visa in last year, but I did not get any positive or negative response. I'm waiting for almost 1 year, and meanwhile, I deferred my semester twice. My next semester is fall 23. My class will start in upcoming September. Should I proceed on filing the petition for writ of mandamus, and how long should I wait till I get my result?
Yes, I would advise you to apply for writ of mandamus, and also I would say you will get your result within 60 to 90 days. I cannot guarantee 100%. Nothing can be guaranteed for 100%, but based on my experience, you will get it within 60 to 90 days. So yes, I advise you to apply for mandamus.
Thank you so much, Mr. Mahajan. I hope that answers your queries, Mr. Hussain. And those were all the questions we had in our archive. We have also answered several questions in our from our live stream viewers. And up till now, we have no more questions. Thank you so much, Mr. Mahajan, for your time. As for the viewers, please join us in the same time next week as well in order to get more information regarding any kinds of visa problems or concerns from the U.S. Embassy. This has been your host, 𝗦𝘂𝘆 𝗟𝗶𝘃𝗲. Thank you very much, everyone, and have a great day.
With a 99.4% success rate, Raju Law is one of the largest immigration law firms in the USA. Besides our founder and principal attorney, we have 6 associate attorneys along with 100 law clerks, case managers, and officials. The law firm is headquartered in Washington, D.C. Other than that, there are a branch office in Georgia and a country office in Dhaka, Bangladesh. What is a writ of mandamus? In simpler terms, in the immigration process in the USA, a writ of mandamus is a remedy for visa applicants using which they can effectively address and resolve the unreasonable delay in their visa processing. Why should you file a writ of mandamus? If anyone's visa application is stuck in an administrative process, he or she may file a writ of mandamus requesting the court to ask the concerned embassy or consulate to adjudicate the visa application within a reasonable time. Who can file a writ of mandamus? Anyone can usually proceed with the writ of mandamus if the administrative processing has been ongoing for more than 2 months for a student visa and 6 months or more for a visa of other categories. Processing time. After filing a writ of mandamus, it usually takes around 6 to 8 weeks to get a response from the concerned agency like USCIS, embassies, consulates, or others. For writ of mandamus and any lawful immigration-related services, contact the address and phone number shown on the screen. You can also mail at info@rajulaw.com. Rajulaw is your trustful address for any assistance and advice regarding immigration to America.